So, unfortunately, we have many states that now have zero tolerance per se laws, and because this PowerPoint is on your DVDs, I'm not going to go through these with too much detail, but you can see Arizona, Delaware, Georgia, Illinois. In most of these states, there's mandatory jail stints associated with driving if you have these substances or inactive substances in your blood or urine, and if you are in an accident and there is serious injury, then these laws really kick into effect with much more serious penalties than things like 24 or 48 hours in jail. Now you're talking, years or decades in jail. Michigan, like I said, we're going to talk about shortly.
So you're in jail for Indiana.
So, as you can see now, there's about 14 states that have passed these laws. Most of these laws were passed about 8 or 9 years ago. It seems the legislatures seem to be much more hesitant in the last couple of years to pass these sort of laws, probably because some people like us have begun testifying against them. Congressional action. Here's my big fear. Is that Congress is simply going to come out and say every state needs to pass a zero tolerance per se law, or you're going to lose your highway funding. This has been proposed. That bill didn't go anywhere. So then a couple of years ago, DOT, in an appropriations bill, was ordered by the White House to basically come up with an ideal law. And since I know people like John Bobo and Michael Walsh and the California Narcotics Officers Association are the ones that are coming up with the ideal law, I think it's fairly safe to say which side of the law they're going to come down on. Anyway, DOT has been mandated to come up with recommendations for developing a model statute for states relating to drug driving. These should include threshold levels for impairment for illicit drugs, practical methods for detecting the presence of illegal drugs, and penalties for impaired driving. Fortunately, things in Washington work very slowly. So although we are well more than 18 months since August of 2005, these recommendations have not been written. I don't quite know where they stand. I do know some people that are involved in this process, and they say they don't know where they stand either. So in this case, delay is a very good thing. NHTSA, National Highway Traffic Safety Association, they gave the Walsh Group, Michael Walsh of Bethesda, Maryland, a contract to basically quantify how many drug driving cases there are. That report also hasn't come out. Rosita 2, the only reason I mention it is because this is the program where they want to take saliva from drivers. They're actually already doing it in a few states. They do it in Europe. Interesting insight into the mindset of police officers. When they did this test in Europe, they found that saliva testing was not satisfactory at the roadside in terms of ease of use. The cops couldn't figure out how to use it. Sample volume needed, that means they couldn't collect enough saliva. Sensitivity, it means most people tested negative even when they should have tested positive. Or reliability, which means the test wasn't accurate. Despite all those problems, police said they would rather use this imperfect test. Can Zero. Okay, this is going to Michigan. This I do want to highlight. Can zero tolerance per se laws be interpreted strictly? This idea, would the courts actually okay a person going to jail even if they weren't impaired simply because they had these inactive substances in their blood? So then we get to Michigan, Dolores Darer. She is driving her vehicle in January, 6 o'clock at night. It's dark, snowy road. She weaves, she goes across the median, she hits another vehicle. The woman she hits is killed. 2 children in the back seat are paralyzed. When they search her purse looking for identification, they find 5 marijuana cigarettes. She later claimed she smoked at 2 o'clock in the afternoon. She probably shouldn't have said that, but she did. So they gave her a blood test because under Michigan law at this time, a person who has any presence of THC in their blood is per se guilty of drug driving. Well, they tested her 4 hours after she said she smoked pot, and guess what? They don't find any THC in her blood. That's actually fairly consistent with the fact she probably isn't a regular user and actually did smoke pot many hours before and wasn't high anymore. What they do detect in her blood is carboxy-THC, the inactive, non-psychoactive metabolite of marijuana. No surprise it's in her blood, it's a byproduct. They found 31 nanograms of this byproduct in her blood, and they tried to prosecute her. But the Court of Appeals said that this inactive metabolite is not psychoactive, nor is it classified under Michigan law as a controlled substance. The law was not meant to convict people like her, is basically what they said. They also said, we did not intend to impose strict liability on an individual involved in a driving-related accident. That's because this law was amended to the drunk driving law. And there is precedent that says, if you're going to be prosecuted for drunk driving, well, then you have to have recently drank alcohol and be drunk. So they said it doesn't make any sense that we would treat drugs any differently. And they said imposing a penalty on a driver when the accident would have occurred regardless of that intoxication would fail to serve the purpose of the statute. It actually makes sense to me. Fortunately, it didn't make sense to the Michigan Supreme Court. They actually said that even though the legislature made it a point not to include metabolites under the law, they actually meant to. That was their intent, they simply forgot to say so. The fact that there are other statutes in the state of Michigan that do talk about metabolites, and this one specifically did not talk about metabolites, was not persuasive to the court. They read the legislature's mind. The fact that the statute does not require the defendant to be impaired while driving, that was also irrelevant to the court. It was irrelevant that the ordinary person cannot determine without drug testing when a Schedule I substance is no longer detectable in the body. It didn't matter that the substance they found in this woman was not a Schedule I drug under Michigan law. That was irrelevant as well. And finally, it is irrelevant that a person who is no longer under the influence of marijuana could be prosecuted under the statute. That it might apply to some persons who are not actually under the influence of marijuana does not render the statute unconstitutional. So the bottom line, these laws are neither a safe nor a sensible way to identify impaired drivers. They are attempt to misuse the traffic safety laws in order to identify and prosecute marijuana smokers per se. Those are my words. Unfortunately, they're not the words of the Michigan court. Zero tolerance per se convictions are based not on impairment, but on individual status. Are you or are you not a drug user? If you're a drug user, you are guilty. But maybe they make us safer. Unfortunately, there's two papers that have now assessed states that have these sort of laws, and they found zero concentration laws have done nothing to reduce DUID or deter the typical offender.